Our speaker today is Dr. Ryan Owens, who is a professor of political science and affiliate faculty at the UW-Madison Law School. He also is an honorary fellow in the Institute for Legal Studies. Dr. Owens earned his PhD degree at Washington University in St. Louis and a JD from UW-Madison. He studies law and courts and American political institutions. His work analyzes the United States Supreme Court, the United States Court of Appeals, legal institutions, and judicial behavior. Today, he will tell us about the past, present, and future of the United States Supreme Court. We look forward to your presentation, Dr. Owens, and we've made a contribution to the International Polio Plus Fund, as well as giving you a copy of our centennial history in honor and saying thank you today. So as we welcome Ryan to the podium, just a quick reminder that hopefully we'll have questions at the end, and there will be microphones that will be circulating around. So please welcome Dr. Owens.
All right. Well, good afternoon, everyone. Good afternoon. Thank you very much. All right, in the spirit of Sesame Street, I think I have to say 9 justices. All right. So there you go. All right, thank you. I need that. So one of the things that wasn't mentioned, of course I should have told you this, but in addition to all that other stuff, I'm also the incoming director of the Tommy Thompson Center on Public Leadership. It's a center that I've created, we're working on creating on campus right now, devoted towards public leadership, to instilling leadership ideals and goals in our students. It seems to me that students coming in thinking that people like Kim Kardashian are leaders is crazy. All right, so we're working with Governor Thompson and others right now to create this center, and it'll be focused on enhancing collegial leadership among our public leaders, along with taking leadership over certain substantive topics of importance. So keep your eyes peeled for that. We haven't formally got it off the ground yet. We're in the fundraising stage of things, but I suspect that shortly we will be moving forward with that. Now, one of the reasons I bring this up is because I'm thinking about it a lot, right? But another reason I bring it up is because it touches, I think, at least tangentially on what I'm going to talk about today, which is the past, present, and future of the Supreme Court. By the time I conclude, I will have offered at least some thoughts on potential reforms that we could make to enhance the perceived legitimacy of the court and maybe the system we use to select justices. So I wanted to start off with this quote here by Chief Justice Roberts. It's one that he delivered about a week, maybe 2 weeks ago now, in the aftermath of the Gorsuch confirmation. And essentially he said it's going to be very difficult for members of the public to take a look at justices who sit on the Supreme Court and not think that they, too, reflect that partisan polarization that we see. And if all you do is you look at confirmation hearings and you see the back and forth that goes on between Republicans and Democrats, you may think that that same kind of behavior motivates justices when they get on the Supreme Court. Now, it is, of course, true that justices are ideological decision makers. I'll show you some data to suggest that. But it's not to suggest that they're motivated completely by that, or that the kinds of decisions they make are like the kinds of decisions that members of Congress or other politicians make. So we need to be very careful. And I think that's what Roberts was suggesting. So here's what I want to do today, 3 things. The first, I'm going to move us through a brief thought experiment about what we can expect in terms of composition on the court in the future and what we could have expected under a Clinton presidency. And then I'll talk about the evolution of justices' ideologies on the court since about 1937 or so, and then I'll make some suggestions about possible reforms. All right, so here's our thought experiment. We, of course, have the Trump presidency with a Republican Senate. And so the question is, what can we expect in terms of composition? So here is the dynamic, the composition of the court that President Trump faced when he got into office. All right, so we have Sonia Sotomayor on the left, then Ruth Bader Ginsburg, Elena Kagan, Stephen Breyer, Anthony Kennedy, Chief Justice Roberts, then the vacancy that was held by Scalia, and then Justices Alito and Thomas. All right. So what did he do? He nominated, and the Senate confirmed Judge Neil Gorsuch from the 10th Circuit. Okay. Now, what does this mean? Well, actually, it meant 2 things for us right now. The first is it means Trump got a conservative judge on the Supreme Court. I don't think that's a shock to anyone. But it's unclear just how conservative Neil Gorsuch will be on the Supreme Court. There is some data to suggest that he will be potentially as conservative as Justice Thomas, maybe a bit more. That's fine. That's what people voted for in the presidential election. Okay, so we have that. But perhaps more importantly for us right now, what it did is it had the effect of keeping Justice Kennedy as the median justice or the swing justice, the one in the middle. Right? Now, this is important because what we know is that the way the democratic process works, the person in the middle usually wins out. Okay? Because when given a set of choices, people can go back and forth. Let's say you adopt a conservative position, somebody on the left can counter that with something a little bit more moderate. What eventually happens in these majoritarian institutions is that the middle position tends to win. That's why the median justice is so important. Okay? Well, Kennedy's been the median since 2005. Before that, it was Justice O'Connor. So it's no surprise that we used to hear all kinds of commentary about O'Connor and now Kennedy. All right, so Kennedy gets to remain on as the median justice, and therefore policy on the court will tend to remain sort of moderate. Okay? Well, what happens next if Justice Kennedy retires? Now, I've heard that he has plans on retiring at the end of the next court term, potentially sooner. So what happens at that point? Well, let's say that President Trump nominates somebody like Paul Clement to be on the Supreme Court. Clement was not on Trump's original shortlist, but he should have been. He's a brilliant lawyer, whether you agree with him ideologically or not. And if Trump puts him on the Supreme Court, what does he get? Well, he gets another conservative on the court. And let's say Clement is potentially a little bit more conservative than Alito. I'm not sure that he is, but just bear with me. What effect does that have? That means that the new median justice, the new swing justice on the Supreme Court will be Chief Justice Roberts. Okay? For people like me, this is going to be absolutely fascinating because this will be the first time since 1937 that the Chief Justice will also have been the swing justice on the Supreme Court. And even in 1937, Chief Justice Hughes, it's not altogether clear that he was in fact the swing justice. So Roberts would have all of the institutional prerogatives of the chief, such as opinion assignment, seniority norms, the like of those kinds of features, as well as the informal powers of being the swing justice on the Supreme Court. This would make him, in my estimation, the most powerful justice on the Supreme Court, probably since John Marshall. Okay? And this would be fascinating to see, the alignment of these two things. All right, well, where are we here? Ruth Bader Ginsburg is 84 years old, right? Actuarially, it's tough to tell how long she'll be able to stay on the court. If she is forced to retire, and she certainly will not do so voluntarily under President Trump, if she involuntarily leaves the court, let's say that Trump gets somebody else conservative on the court. Now the median shifts over to Sam Alito. Okay? Interesting dynamic. Now we have a 6-3 very conservative Supreme Court. All right, now, here's the thought experiment. What would have happened had Clinton won the White House? And let's say coattails being what they are, she takes a Democratic Senate with her. Okay, here's the vacancy for Scalia when she gets on the court. Let's say she puts somebody like Goodwin Liu, a liberal judge from the California Supreme Court, somebody that Obama nominated to the Ninth Circuit, but Republicans filibustered him because they thought he would be too liberal. She gets him on the court. Now the new median becomes Stephen Breyer. This would be interesting because take a look at these voting figures. Since 2005, Anthony Kennedy has cast 56% of his votes in the conservative direction, while Stephen Breyer has done so only 43% of the time. This would be a fairly sizable shift. Okay? Well, let's say Kennedy then retires again. He's replaced by another liberal judge. This would shift the median to Elena Kagan, who voted liberally more often than not, only conservatively 41% of the time. Okay? Well, Ruth Bader Ginsburg would unquestionably have retired had Clinton won the election. Let's say she's replaced with another liberal that keeps Kagan around. Now, let's say that Stephen Breyer then retires. I suspect that he would have retired as well. And let's say Clinton puts another liberal on the court. That shifts the median justice over to the liberal Goodwin Liu. Okay? look at the distinction between these two potential courts. In one instance, you have a 6-3 very conservative court. In the other instance, you have a 6-3 fairly liberal court, right? All from one presidential election. Now, I would suggest to you that this is probably not a good dynamic. It's probably not the kind of thing we want for the Supreme Court, or frankly, for the lower federal courts either, right? Now, I talked a lot about ideological behavior among the justices. Can I validate that? Sure, I can. Let's take a look, okay? What I have up here right now is the proportion of cases over time on the Supreme Court where there was a separate opinion written, either a concurring opinion or a dissenting opinion. And what you can see from this data, even though if you can't see the years, which are on the bottom of the figure, you can see a huge uptick at one point in time, okay? That happens to be, no shock, the New Deal, okay? What court watchers and scholars observed at this time was there had been, previous to this, very little dissenting behavior on the Supreme Court. And then all of a sudden during the New Deal, bang, we see all kinds of dissenting opinions, typically by the same justices, okay, in the same kind of direction. And so it led scholars to start to collect data on justices and the kinds of behaviors they exhibit, okay? What I have up here for you right now is the next figure. The dots on this figure represent the ideological location of the median justice in a particular year. Okay, so the far left, we're looking at 1937. The far right is today. Dots that are lower on that graph represent more liberal behavior by justices, and dots that are higher up represent more conservative behavior. Now, what you can see is quite a bit of variation, but you can see that the median kind of changes over time and accords with conventional wisdom in terms of what we think the court was during the 50s, 60s, and then since. So we've seen for the last 20 or 30 years a fairly moderately conservative Supreme Court. And that's, just in case you're wondering, the dashed lines behind there represent the percent of conservative votes by the court in that particular term. So you can see that as the median becomes more liberal, the court issues more liberal decisions. When the court median becomes more conservative, you get the converse, okay? So here's a figure that I actually really enjoy, even though I'm colorblind, okay? These dots here represent the ideological estimates of each justice in each term since 1937, right? So each year should have 9 dots on them, right, in vertical order. And each dot is a particular, each justice is a particular color. So what you can see is something that accords with conventional wisdom, right? Some justices are quite liberal, some justices are quite conservative, and we kind of see a dynamic that shifts a little bit over time. So let me just walk you through that very briefly. So the individual who's sort of anchoring the left here is Justice Douglas. He gets on the court, he's a liberal New Dealer. He moderates a little bit in the late 30s or early 40s. He still has some political aspirations. And once he sees that those are out the door, he turns to the left and he never looks back, not a single time. Okay, he's definitely the most liberal justice we've had in modern history. Take a look at these two folks here. We've got Justices Brennan and Marshall. That accords with what we think of them, two of the more liberal justices in recent years. There's John Paul Stevens, who starts out as a moderate, and he drifts to the left over his time on the court. Here's Justice Blackmun, well known for having drifted to the liberal position, and you can clearly see that from the blue dots. He starts out as a conservative, and he drifts substantially to the left over his time on the court. And then finally up here, we've got Chief Justice Rehnquist, who starts out as the most conservative justice on the court, clearly. And he moderates slightly over time, particularly after he gets appointed to the Chief Justice position. That has a tendency to moderate people. All right? So what I want to do is focus on the justices who are currently serving on the court, okay? And sort of explain to you why this past election was really so important. So if you can take a look at the top of the list, it's the same dynamic. Up on top, we have more conservative justices. On the bottom, we have more liberal justices. And you can see that Clarence Thomas is anchoring the right. Right? He's not going to budge from that position. He's been pretty consistent over time. Take a look at Justice Scalia. He starts out as a moderate conservative. He trends to the right over time, but then he comes back to a slightly more moderate position. Sam Alito has been relatively consistent since he's been on the court. But what I want to do now is shift to some of the other justices. So if you take a look at the RBG, right, Ruth Bader Ginsburg, you can see she starts out on the court as a moderate liberal, and she has moved to the left pretty much every single term on the court. Okay. Justice Sotomayor, she starts out as a liberal and she becomes quite a bit more liberal as she serves on the court. Elena Kagan has been relatively consistent in the liberal direction. Now, what I'm really more concerned about here is to have you look at the Chief Justice and Justice Kennedy. Start first with the Chief Justice. He begins as a pretty strong conservative, and after the first 4 or 5 court terms, you can see that he has drifted to the left quite a bit. Okay? Hence the ferocious attacks that he faced from then candidate Trump. Okay? Perhaps more importantly, look at Anthony Kennedy. He starts out as a conservative, almost of the ilk of Justice Scalia, but has drifted to the left nearly every single term since he's been on the court. And indeed, the last couple of court terms, his voting behavior has been more liberal than Ruth Bader Ginsburg was in her first court term, which is shocking. Okay? It's shocking. That's why this presidential election was so important. Right? Who was going to fill that position that Scalia left vacant? Who was the new median going to be? Was it going to be Anthony Kennedy? Or was it going to be somebody down closer to Stephen Breyer and potentially more to the left? Okay. Now, the thing is these figures are cute and they're interesting and I really like putting them together. But the thing is that the political actors know this as well. They know this stuff. Okay. That's why you had Merrick Garland's nomination stalled. That's why you had Gorsuch's nomination filibustered. Okay, political actors know all of this stuff, and they're going to fight like hell to win on it. Okay, and of course, don't let anybody fool you. Had the Republicans been the minority in the Senate, they would have filibustered somebody like a Gorsuch or a Merrick Garland. Had Democrats been in control of the Senate before the election, they of course would have stonewalled the nomination as well. So all of this stuff is nonsense that we're hearing about how, we would never have done this. You both would have done it, okay? That's how this stuff works, okay? Now the question is, do we want it to work that way? And I would suggest to you the answer is probably not, okay? And so what I would like to just sort of think about a little bit is whether or not it's time for us to reform a few things dealing with the court. Okay, and specifically, I would suggest we might want to contemplate age limits for justices or request them to ride circuit again, as they used to in the past. All right, now these, I'm not going to come down hard on any of these. I think these are things we ought to just start discussing at least. So in terms of age limits, right? So we're not going to be able to rid the court of ideological behavior. It's just something that's going to be there. Okay? So what we want to do is to try to contain its effects a little bit and contain the effects that spill over into the confirmation process and elsewhere. And this is a potential solution. So we are the only common law country right now that doesn't impose some kind of a constraint on its justices in terms of their tenure. Okay? You have lifetime tenure for however long you want to stay. There is no feature in there for what happens if a justice becomes incapacitated. There's nothing in the Constitution that forces them to retire or get their colleagues to sign a letter saying they're not mentally competent any longer. And this has been, over the course of history, a problem for the court from time to time. Okay, so no other common law country has this sort of dynamic. And in fact, only one state in the Union has unlimited lifetime tenure for its justices, and that's Rhode Island. Every single other state has at least some kind of provision, either a strict age limit or an election or something, that would serve as a potential check on this kind of a problem. Okay, so it's something that we ought to consider. It would have the effect of maybe diminishing potential mental decrepitude on the court, which is a sort of a term of art. The other thing is it would remove the incentive for justices to retire strategically. Okay, I think everybody's probably heard the story that in 2000, when everybody wrongly called the election for Gore, Sandra Day O'Connor was at a party and she said, "Oh, this is horrible. Now I have to sit for another 4 years. I wanted to retire." Okay. Well, the same thing, of course, applied in this last election when Ruth Bader Ginsburg made some not very nice comments about President Trump, and I think we all knew that she wanted to retire under a Clinton presidency. So, imposing a strict cap on an age limit might help facilitate the sort of workaround for strategic retirements. Now, the other thing that we could consider is circuit riding. So early on in the court's history, justices were required by statute to go ahead and travel throughout the country and to hear cases as trial court judges. Okay, it's kind of a strange dynamic, but each justice was considered to be a circuit justice, and they would travel out there and they would sit with district court judges and decide cases. Now, it's sort of unusual because cases that were appealed then would go up to the U.S. Supreme Court, and those same justices would then sit in review. But there are, of course, workarounds for that. But it had a number of interesting effects. The first is it forced justices to go out in the community and interact with people they might not otherwise have interacted with. Okay, I think that's probably a good thing because we know that the more people see the Supreme Court, the more they like the Supreme Court. So this would help them get out there and expose citizens to the court more and potentially drive up the court's legitimacy. The other thing it would do is it had the effect of sort of having justices see the effects of their rulings. And we don't have many justices today on the court who were trial court judges. And so oftentimes when they're deciding cases about juries, jury instructions, like they may not know exactly what they're doing. But if they have to go out and see the effects of their decisions, they might think a little bit more about some of the decisions they make. All right. And finally, of course, if we're concerned about sort of mental incapacity among the older justices on the court, having to travel across the country may have an incentivizing effect and sort of leading them to retire if they become uncomfortable with having to travel a lot, which is one of the intents that it originally had. Okay, so why do we care about this stuff, right? We should care about it because a strong and independent judiciary is important to us. We want to protect the court. We want to protect the rule of law. Now, we have to be very careful, of course. We were speaking earlier about what happens when you have judges sort of go well beyond their prerogative. We need to find a way to sort of restrain them a little bit, but I think that can be done internally within the judicial system. Externally, I think we need to protect and foster a strong and independent judiciary, and I think these are some of the reforms that we could contemplate that would maybe help the court and the system in the eyes of the public. All right, so I'm going to stop there, and I'm happy to take any questions. Yeah, 3 years in jail for stealing my nose. Got your nose. All right. Oh, thank
you. Anybody on this
side? Thank you very much. I have a question about ageism. Is there any studies to show how effective a Supreme Court justice is?
Yeah.
Because if you look at the voting, of these justices and the rationalization for their decisions, some of the justices raise questions which are very sharp and very effective. Mm-hmm. Others raise very few questions, like Clarence Thomas. Right. When you say a person over the age of 65, I'm 83, and I don't consider myself demented yet, anyway.
I knew that would go over well.
But I think the idea is that age is not the criterion. What the criterion should be is effectiveness. If you have, say, a person who's demented at the age of 55, mm-hmm. he's below 65, he can stay on there. Sure. For your criterion. Mm-hmm. It's not the question of age. I mean, some people, begin to age very rapidly, even before 65. Right. So I think the important criterion is effectiveness. Is there any standard that you have, that you know of, how you would evaluate each one of these 9 justices and say, this is a very good judge because he asks great questions, he has great briefs, and he really is prepared. Well, this justice, just goes along with the decision. Mm-hmm. Thank you.
Yeah, thank you. That's a good question. We don't, as scholars, have good estimates right now of the effectiveness of a justice. Measuring that would be pretty difficult to do. I can tell you that a colleague and I right now are working on a study where we want to try to determine whether we can detect early signs of dementia in justices during oral argument. Okay, there's software out there that lets you compare the vocabulary of individuals and their patterns of speech over time to see whether or not that's kicking in. So we want to look into that because there is evidence to suggest that later on in his career, Thurgood Marshall, for example, was not mentally fit. That Justice Douglas, the same. I mean, there are numbers of examples of that over time. So effectiveness would be the scalpel, and the 65 or 70-year age limit would be the axe. I got that. I'm with you on that. But it may be more administrable to impose an age limit than trying to measure effectiveness and the like. So I'm with you in theory on this one. And if there are more manageable ways to kind of get at this problem, I'd be all for it.
Thanks. At the end of the Obama administration, there were many who felt that, or some maybe, who felt that he had the right to appoint Merrick Garland to the Supreme Court because Congress refused to comment or to consider it. Is there what's your legal view on that?
Well, constitutionally, the Senate was well within its power to not do anything. That was well within their constitutional prerogative. Now, the question is, there's a difference between something being constitutional and being good government, right? I don't want to take a position on whether they ought to or ought not to have confirmed Merrick Garland. I think I'll just say simply that number one, it was their constitutional right to do that. But number two, what we see is that in these confirmation battles, once you ramp it up one direction, then the other party ramps it up, and then the other party ramps it up. So Senate Democrats got rid of the filibuster in November of 2013 for lower federal court nominations. Then Republicans, refused to move on the Garland nomination. Now we have to get rid of the filibuster for the Supreme Court. What comes next? I've heard comments from some on the left that say that they might want to pack the court the next time you have a Democratic Senate and president, maybe increase the number to 11 or 13. That would be an escalation. I mean, we see continual escalations over time and over time and over time. I'm not sure the best way to put an end to that. Something like this potentially limits on when justices can retire. There are other proposals out there that would impose 18-year term limits on justices. That's something maybe we want to consider. But I don't think that the Senate and the president together are going to solve this problem. I think it's going to get a lot worse until it gets better.
But did the president have the constitutional authority to make the appointment without the...
A recess appointment?
No, not a recess appointment, just an appointment without Congress, without the Senate confirming?
No. I mean, for the Supreme Court, unless you make a recess appointment, which they would not have been able to do here because the Senate was in continual session, absent a recess appointment, there's nothing that the president could have done. It's the way it goes.
Thank you for being here today.
Yeah, thank you, Ron.
So during this term with the court fully composed and it kind of being status quo, are there still some cases out there that will be decided before June 30th that might create some more seismic changes?
The big one I think that most people are going to talk about is the Trinity Lutheran case. So this is an interesting case that comes out of Missouri. You have a daycare run by a church that applies for this sort of playground reimbursement thing. So Missouri had this program where playgrounds that had these small pebbles in their playgrounds, right, they could have those replaced with shredded tires. It's a great way, you get tires, out of the market, get people burning tires or junking them. You get them cut up and then they put them on these playgrounds. Well, playgrounds and schools could get reimbursed for the cost of changing these things out. So they opened up this policy. They said to everybody, you can apply for these things, for these grants, and here are the standards by which we're going to hold you accountable. And so this church, Trinity Lutheran, applied for it. And surprisingly, what happened is the state of Missouri went through and ranked it. Okay. Now, the guidelines for Missouri said that religious organizations couldn't get these things. But nevertheless, they went ahead and ranked it anyways and found that this application rated as 5th out of 44 applications. So they made a very good case to get the funding. And then Missouri says, oh, oops, we forgot you're a religious entity. You can't get any of these funds whatsoever because Article 1, Section 7 of our Constitution prohibits public monies from going to any religious entity. Okay? So Trinity Lutheran says, hey now, we were ranked 5 out of 44 on this. Clearly, we merit consideration and approval for this process, but you've denied us the right to apply for it simply because we're a religious entity. That violates our free exercise rights and the Equal Protection Clause. Okay, so right now the court is considering whether or not the decision to not allow an entity to participate simply because they're religious violates the First Amendment's free exercise right. And I think Neil Gorsuch stands probably fairly sympathetic to Trinity Lutheran. This case was granted by the court back when Justice Scalia was still alive, and then they held it over until now, which means to me that there were 4 votes to grant review to this case, with Scalia being one of the 4. And they didn't know what to do with it in his absence, so they just held and they waited. Now they've heard the case that was orally argued last week, and this will be one of the blockbusters that remain. Yeah, you're welcome.
I noticed on your slide of all the current judges that they all seem to move to the left over time, which seems to be opposite of what you would think would happen. Do you have any comments on that?
Well, so a couple of comments. One is, for some of these justices, that's really the only direction they had to go. It's sort of a regression to the mean, right? For Thomas, Scalia, and whatever. I can't see them getting particularly more conservative, especially with the current composition of the court. So that seems to me just an artifact of regression to the mean. But for folks like Sotomayor and Ginsburg and Kennedy, why they shifted to the left is a little unclear to me. I have a couple of thoughts. One is, I think, certainly for Kennedy, Elena Kagan, her introduction to the court and her time on the court, she has been amazingly effective. Okay, she can influence Kennedy. I think she's the Kennedy whisperer, all right? I think she knows what Kennedy wants. I think she knows his weaknesses, his strengths, and I think she's able to tap into those really effectively. I think we shouldn't discount the influence that she's had on the Supreme Court. The other thing I think it's been is honestly strategically poor predictions by the conservative justices. I think they've been granting review to cases to try to change precedent, and I think they've been overestimating their probabilities of success. So they've been putting cases on the court's docket that they thought would be a doctrinal shift to the right, but were simply too far to go for people like Kennedy and maybe Breyer. And so it looks to be really, really sort of enhanced liberal decision-making by some of these justices is more a function of just poor strategery, right, by the conservatives and putting some of these cases on the docket.
Hi, thank you for being here. Can you talk just a little bit more about, it's a methodology question, like how you're categorizing decisions as liberal or conservative?
Yeah, so thanks for the question, and this will be the last one. It's this is so hard, and I have to go. It's a standard sort of political science approach. It takes into consideration who wins, who loses, what happens to the precedent, that kind of thing. So they are somewhat blunt. We're working on ways to kind of improve them a little bit, but it's pretty agreed upon approaches. You take the winners, the losers, and over time from those and the dissenting behavior of the justices, you can extrapolate how they differ from one another and where on an underlying latent sort of ideological spectrum they fall. Right. So there are a number of things that we can do. This is voting behavior and voting on the merits. There are other approaches that we have taken by looking at the comments justices make during oral argument to help give us some sort of words as data approaches to this. We can look at everything they've written before they got on the Supreme Court, and all these things kind of line up to give us the same general patterns. Sorry, I can't give you a more specific answer than that, but I'm happy to talk about it later if you'd like. So anyways, thank you very much. Appreciate it.